Good evening and welcome.
Good evening. Thank you for allowing me to speak here today. My name is Frank Sicoscio. I am the president of the Rhode Island Second Amendment Coalition. I'm also the Assistant City Solicitor for the town of Johnston. I do the criminal prosecutions in the district court, so I'm very familiar with the domestic violence issues and what actually comes in front of district court. So I'll try to give you my perspective that I see each and every week in the court system with this. I'd like to begin talking with regarding Senate Bill 593. Senate Bill 593, I would be in opposition to this bill as it is written. The way that what happens with the disorderly conduct section that we have right now, which is 1145-1, the language in there that's in Section C gives the judges discretion. In the event that this is the first time someone's coming into court and the case is not very egregious, it says clearly in Section C, any person found guilty of the crime of disorderly conduct shall be imprisoned for a term of not more than 6 months, comma, or fined not more than $500 or both. Judges have the discretion to take a look at this and impose the sentence that they believe is appropriate. Taking a look at the language change you have now to 593, Section C has been changed. Section C eliminates the discretion of the judge on that and puts it, any person found guilty of the crime of disorderly conduct pursuant to Section A1 through A5 shall be fined not more than $500. That gives somebody a conviction right out of the gate. That's going to be a real problem with regard to administering these cases in court and trying to make sure they're properly adjudicated. Whenever you take the discretion away from a judge and you tie their hands, not going to end up very well, especially if it's not a very egregious crime. Sometimes you have disorderly conducts that are not violent. People get into an argument, yelling and screaming. Now a person's going to get a conviction right out of the gate. Really not appropriate in some of these cases. Judges no longer have the discretion to say, you know, we're going to put you on a filing. You can't be doing this. Hope you learn your lesson and whatever. You can't do that anymore. You've locked the judge's hands. In talking to some of the senators before this thing came forward, some of the senators were under the impression that this was simply just a simplification of the law and would make it easy to adjudicate. I don't buy that. I don't buy when you take the judge's discretion away and you're saying, well, it's simplifying it. It's simplifying by making everybody have a conviction on this. It takes away the discretion of the judges, which is a problem. Okay? Now,
Senator Archibald.
Just Sicoscio, if I can just interject for a minute. I like 90% of the bill and the decriminalization of of disorderly conduct, because we deal with it so often and we find it so rampant. In fact, we take charges when we have unwilling witnesses and we try to put them into some category to get a hook on them as prosecutors. We want to tie them down. So it's a sound area to go, but I couldn't agree with you more. I think the bill's almost there, and I like the carve out to make it domestic violence and to make the other petty areas of the disorderly conduct non-criminal as violations, but at the same time, you can't erode judicial discretion. I have great concerns. I talk at length about eroding judicial discretion, and this does tie that. There has to be a change to a couple of the words that loosen up the ability of the judge to retain judicial discretion.
Senator Lombardi.
Yeah, and if I may, I think it just may be an issue of drafting. I think there's an unintended consequence here. I think the goal is to decriminalize a particular action of disorderly conduct, not to include domestic disorderly conduct.
Absolutely.
And that's you know, and I see that point. But in so doing, the shall part that creates the fine creates the conviction. So in essence, when it tries to decriminalize, it actually criminalizes it all over again.
That's correct. It also dovetails in from 593 into 503. There's a section of 503 that refers specifically to 18 U.S.C., which is the federal code, and I'm going to go into that in a minute. But if you give somebody a fine right off the bat on a disorderly, under federal law, they've just been convicted of a misdemeanor, and you've just taken away a person's ability to have a firearm for the rest of their life under that. So it may look on the surface to go, oh yeah, this is fine. But one bill interacts with another bill and could knock somebody off for the rest of their life. Imagine people at a cookout and it got a couple of cousins arguing back and forth and somebody calls the police. and they get arrested and charged with disorderly. They walk into court and the judge says, well, I'll give you guys a $25 fine and you're all set. And they walk out of the courtroom. For the rest of their life, they may not be able to own a firearm ever again. That's where one may affect the other one. Be careful with the unintended consequences on these. The bill, as it's written here, also could create some very absurd results. And let me give you the hypothetical. Two people come into court. One is charged with the disorderly conduct. Another one's charged with a simple assault and battery. If the 593 goes through the way it is, the person who had a disorderly conduct, which may be just simply yelling and screaming, gets a conviction right off the bat. Whereas the person with no record on a simple assault and battery could get a filing, which means that person walks out of court having maybe punched or struck somebody, and in a year it automatically goes away like it never happened. But the disorderly conduct will stay with that other person for the rest of their life. So it really does create an absurd result when you have somebody with a nonviolent offense is convicted, and person with a violent offense walks away and goes, in a year it goes away like it never happened and I don't have to do anything. This is a problem when you tie the judge's hands on something like this. We see this in court every week. You've got to be very careful with doing something like this. It might have on its face some good intentions, but it's got some really bad results when you start looking into it. Okay? Let me actually jump to, and I'm sorry if I'm taking up a lot of time. I know it's a lot of the people that want to talk about this. I'm going to jump into 503. I oppose the legislation as it's written because, one, it is very overbroad in its language. It creates sort of an almost unlawful forfeiture of personal property, and there's a serious unintended consequence, which I'm not sure people have I've looked at this close enough and seen. I know people behind me are really going to be upset when I say this. This has the potential of disarming victims of violent crime later on. The actual victims could be disarmed later on in life, and I'll go into that in a minute. Whenever you take away the discretion of the judges on this, when you say shall to may, especially in the wording of 503, after notice and hearing, it still says the judge shall take away the person's firearms. So why would we give them notice and opportunity to be heard when it says they shall do that after the hearing? There's no causal connection to any of the offense charged or the underlying basis for either a restraining order or a protective order of any violent crime. None whatsoever. So the judge, if they believe a protective order or restraining order is warranted, lose your firearms. And there was no evidence at all that the firearm was ever involved or anything. There's no causal connection. And you took away the discretion of the judge, so the judge has to order it taken away. So again, you have a real problem with the drafting on here where you take away the judge's language on there. Now, for those of us who are in court all the time, we take a look at this. A lot of times you take a look at family court judges, they are very, very liberal. They like to err on the side of caution. And you ask me, why am I going to family court judges? Because one of the sections in here deals with, under a domestic, it deals with the violation 1229-2. It's in the draft language of here. Section 10, violations of provisions of a protective order entered pursuant to 15-519. That's the family court section. So you have a family court judge that enters a protective order, and now they can take away the person's firearm. When you take a look at what is the basis of a protective order in family court, it goes down to something as simple as cyber stalking, sending text messages that would be for the sole purpose of harassing another. So without any basis for a violent offense or threats, they could issue a protective order in there. We see it in district court all the time. Also, if you go down to some of the other definitions on here, harassing, course of conduct that would cause a reasonable person to suffer emotional distress or fear of bodily injury. They put in here with the intent to seriously harm, annoy, or bother the person. It could go as low as a judge saying, well, you're intimidating the other person, going by where, they seem to pop up near their work or whatever. No threats, nothing like that. The judge could say, I'm going to err on the side of caution and issue a protective order. The person at that point, under this section, would have to turn in all their firearms. And everybody in here that practices law that knows it, it is extremely easy to be found in violation of a protective order or restraining order. We have one right now in Johnston. I'll explain to you the quick facts without saying the name. Male and female, the female filed for divorce. She got a protective order in the divorce, probably to get a leg up on it, I'm not sure. Then she goes in, she goes to drop off the kids at the house, he comes out and says, we got to do taxes at the end of the month. I really need the finances. Takes the kids and goes in the house. She goes around the corner, calls the police. He gets arrested, he's charged, and that's going to trial right now. So under this section that you've put in place, that person, if they're convicted, even if they're put on probation, would lose their firearms forever because they spoke to the other person. No threats, no intimidation, no name calling, asked if he could get the finances so they could do the taxes at the end of the month. That's a violation of a protective order and restraining order, and it's just that simple. We have a seminal case in Rhode Island, State versus Conti, and if the attorneys out of here that understand this, they're aware of the basis of this. Mr. Conti was walking out of the post office, held the door open for Mrs. Conti, and there was a protective order. As she walked by, he said, "Hi, Liz," and she walked in. A day later, she's driving down the street. He's going the other way. He waves. She called the police, had him arrested. He was charged, had to go through a trial, and he lost. They said he violated the protective order. That case went to the Rhode Island Supreme Court, and it was overturned. But something as simple as that, how you doing? And you could be right in the middle of this, losing your firearms, and you could be convicted of that. So it really is dangerous when it pulls in protective orders and restraining orders that weren't issued by the district court. You put the language right in here with family court. Now, in addition to that, the change that I also find offensive in here, in the event that there was a problem with a domestic, say there was some violence involved, the judge should have the discretion to say, you turn over your firearms during the time that this is there. There's a presumption of innocence that everyone has until they are actually adjudicated of a crime. The language in here was struck that they could turn their firearms over to a neutral third party. Why does it have to go to a police department and to an FFL? Why can't it go to a third party? So in the event the person does get convicted, they can now put their stuff up for sale because they know they can't own it anymore. It gets rid of the forfeiture on this one completely. Why would you strike that unless people just want guns to be taken away from other people? There has to be a basis or a nexus for this. That language should be put back in so that people won't lose their property. Now, if you're not a gun owner and you don't realize this, some firearms are thousands and thousands of dollars. I was actually amazed. I don't own a shotgun, but I was actually amazed that some of the people that go out that shoot skeet or trap on the weekend, they got $20,000, $25,000 shotguns, one gun. So you're telling somebody if they said, "Hi, Liz," on the way out, they're going to lose a $25,000 firearm forever, and there was no violence? There's a problem with that section of the statute. You really need to fix it. Now, there's also no clear language on the state police, what they do with that firearm, or what they do with it during dependency of this. If the person is convicted, then it's disposed of. You think people are really going to get value for their property at that point? It's probably just going to go away. They're going to get, oh, yeah, we scrapped it. Scrap value. There's also absolutely no language. What happens to the firearms when they go to the FFL or the federal firearms dealer? This statute is completely silent to that. But you know what the problem's going to be? The word abandoned is used in there. An FFL dealer is going to go, "Merry Christmas to me. All of this is mine." According to the conviction, it's considered abandoned. So the person, once again, gets nothing for their property, which tends to be a real problem with that. Now, a couple of the things that I want to make sure I point out with regard to this. The intent of the statute is if somebody commits a violent offense, that they should lose their firearms. That's the way it reads. If it's simple, put it down to its most simplest form. How do you think that would apply if we applied that to a different section of the law? You think the analysis would be pretty good? Imagine if our statutes put down that the first time somebody is arrested for a DUI or a refusal, their license to operate a motor vehicle is gone forever. We're going to tow the vehicle that you have. We're going to impound it, and then we're going to go to your garage. We're going to open it up, and we're going to take that 57 Chevrolet Bel Air or that 66 Corvette, and we're taking that also. Why? Because you've proven that you're not safe behind the wheel. You got behind the wheel, and you were under the influence of drugs or alcohol. So it's a complete forfeiture. Everybody on the panel would say that's terrible. Can't do that. A single DUI and a person loses all their property and can never have a license again? Why are you doing it with firearms? You're doing the exact same thing. People lose their property, no money for it. You could lose your firearm forever. What about somebody that's 18 or 19 years old, is in college, gets a domestic disorderly or something simple? For the rest of their life, they have to do that? Brings me to my last point on this one. And this is something I don't think anybody realizes, but you see it in court all the time. Police departments go to a domestic disturbance. She's got scratches on her face. He's got scratches on her face. Stuff is all a mess in the house because there was a fight, and both of them get arrested. What happens now when that woman who has been a victim probably her whole life of domestic abuse, she goes to court, and instead of going to a trial, she just pleads and gets a year probation. That woman now going to be, if she gets out of that relationship, is that woman going to be disarmed for the rest of her life? So when she's alone, trying to protect her family, she can never have a firearm again? Just put the victims of a violent crime. You made them victims again. There's no way for them to get out of that. Now, in addition to that, you use the word conviction in here. And there's a little bit of a problem that we have to make sure that we deal with here. When it comes to a probationary period, okay, 12-18-3, which is a plea of nolo contendere followed by a probationary period. The statute is kind of vague. A probationary period in Rhode Island successfully completed is not a conviction. What happens during the interim? There's actually some First Circuit dicta that says you're convicted. So during that 1 year period, that's a conviction for you. So how do we address the issue in here where you're convicted of a crime, you turn over your firearms, the police department disposes of them, and a year later you're of good behavior, and now you have a probation that's not a conviction? What do you do to that? Police department's going to get sued because they got rid of somebody's firearm collection, gave them no money for it, when under the statute they weren't convicted. Real problem with that one. That's second time out of the gate. Most times people, first time they get a filing, second time they get a probation. Section is 12-18-3 if you want to take a look at it. And that one, and if you look at the case notes in the back of Rhode Island General Law, it does revert to does alert you to the First Circuit analysis of that. There's a Briggs case that came after that, which is not really helpful. But a probationary period successfully completed is not a conviction. Got a real problem with that one. So until the language of this is changed, I'm going to oppose this. It has some really serious unintended consequences. And I know a lot of people are going to come up here and talk about the victims of violent crimes and domestic crimes. Be careful. The unintended consequences of this case could also make the victims, future victims, disarm victims of prior violent crimes. Because if they're charged also, they can't have a gun anyway, ever. So thank you for your time.
Thank you. Any questions or comments for this witness? Thank you.